Welcome, everyone. I see it's 2 o'clock. What I'm going to do is to give 1 or 2 more minutes for people to join, and then we will kick it off.
Thank you, Marlies. Hi, Angie and Joe. Would you mind just triple checking that the media in the room are media? Thanks.
Yeah, just a note to attendees. If you are not, if you're not a journalist, or you haven't verified, or if we cannot verify that you are a journalist who was invited to this, we will remove you from the call. If you are incorrectly removed, please contact myself or Angie, whoever your close contact was for this invite, and we can add you back in. Thanks.
Excellent. On that note, let's get started. Good afternoon to those in South Africa, or who's in a time zone that it's in the afternoon, and to some of our attendees who it might be early in the morning. My name is Marlies Richter. I'm a researcher at the Health Justice Initiative, and I will be moderating the session this afternoon. Thank you for the people who've been joining us. And just to note that this is very much a webinar or a press conference that's been tailored for the media, and we've approached it as such, and we've left a lot of time for questions and answers. So please make sure that you jot down questions in notes to yourself while our auspicious speakers are talking, because I'll make sure that we will have lots of time to engage. I want to note that this webinar or this press conference is being recorded, and we'll make the recording available afterwards. And then just to give you a sense of the lineup in our line of speakers, we're going to start off with Fatima Hassan, who will provide an introduction to the court case and the events that led up to the releasing of the contracts by the South African government on Thursday. Then we're going to have Jay, who would speak to us about the Johnson & Johnson contract and our analysis of that. Matthew Herder, who's joining us from Canada, will be talking about the Pfizer contract. We have Brooke, who will be talking about COVAX. Nick from the UK will be giving us a perspective from the United Kingdom, and then Tahir will be talking about from a perspective of the US. So I have warned the panel that I'm going to be very strict with timekeeping, and I've given everyone 3 to 4 minutes, and I've asked for 3 ideas to be shared. You will note when we release our analysis and the contract, will receive a URL, and we'll open that up at Hoppers 2, that there's an extensive document with an in-depth analysis of the contracts. And our panel this afternoon has been invited to highlight key aspects of it. So I'm going to hand over to Fatima. Fatima is the director of the Health Justice Initiative, and she'll provide some background and an introduction to this case. Thanks, Fatima.
Thank you, Marlies. So I think if we were all in person at this point, I would be saying a huge amandla. And I'm saying that because it took an NGO to go to court at a time when NGOs are being attacked in our country for using the Constitution to advance the rights of people who are marginalized and who are not protected. So just want to also offer our solidarity to groups who are being wrongly accused of perverting our Constitution when what they're doing is actually fighting for more transparency and accountability in our country. And I think it's unfortunate that politicians from across political parties have such dangerous views of NGOs, because I think this case has shown that when an NGO wants to actually use the Constitution to create the precedent for greater transparency in our country, that is possible. We also just secondly want to acknowledge the role that the Minister of Health has played in this, despite his department, we believe, unduly resisting the opening up of the contracts in this particular case for the better part of 2 years. He took, in our view, a very prudent and wise decision not to appeal this judgment, to comply with the court order, and once again reaffirm that the rule of law has to be respected and has to be promoted in South Africa. So we are thankful that the minister handed over the documents, which was given to our lawyers, Power and Associates, on Thursday night. For the better part of 4 days, this multidisciplinary group, you can see the logos on the screensaver, has worked day and night, and for which we're really grateful, to analyze all of the documents and agreements that were handed over in terms of that disclosure. There are still additional documents that will be handed over. We've agreed to an extension to the end of September, and that is all the negotiation minutes and meetings and outcomes. So that would involve companies that we didn't sign a contract or an agreement with. So our analysis in the past 4 days, and as Marlies mentioned, the analysis will go live at 2:30 on our website, but that on the link with the contracts will be available for everyone in the world to see. Those are 4 contracts: a contract with Pfizer, a contract with Johnson & Johnson, a contract with Gavi, which is a not-for-profit initiative, which was administering COVAX, and then the contract with the Serum Institute of India, which was for the version of the AstraZeneca vaccine. But as you know, South Africa paused the rollout of that particular vaccine in its program. And our analysis is as follows: that unfortunately, all of these contracts and agreements prove what we thought was happening all the time, and that is that they are one-sided. All the power has remained with the pharmaceutical companies and also Gavi. So we believe that what we are seeing in these particular sets of documents and agreements, and there are some, the analysis explains what was not handed over, and we hope to receive that quite soon. But what it shows is the story of pernicious pharmaceutical bullying and heavy-handedness. The terms and conditions in these contracts and agreements are so one-sided and so in favor of multinational corporations that they beg a belief. It has placed governments, including South Africa, especially other countries in the global south, in the unenviable position of having to secure scarce supplies in a global emergency, in a manner which basically can only be described as a set of ransom negotiations. There was so much of secrecy, no transparency, and very little leverage against late or no delivery of supplies when South Africa was really waiting for supplies and needing them. And we also believe we have played inflated prices in almost all of these agreements when compared to prices charged, particularly, ironically, even to higher income countries. And this has resulted in gross profiteering. And so basically, we believe that our country, and that means us, the people of South Africa, who put up billions of rands to actually pay for these vaccines, that our sovereignty was taken away at the behest of very powerful pharmaceutical companies who are unelected and basically hold no public office in our country. And this should never happen again. It's unethical, it's immoral, it's extractionist, it's imperial-minded. And the deference and the fear of pharmaceutical companies in the middle of this pandemic has to be addressed at a global level. At minimum, there should be an investigation into Johnson & Johnson and the way it managed to extract a restriction on export bans that were being imposed in other parts of the world, but we were not allowed to do that to benefit Johnson & Johnson in its own agreement, a separate agreement with Aspen Pharmaceuticals in South Africa. And so finally, before I hand over to the different speakers who will go through each of the 4 different contracts, what we believe is a multidisciplinary group and what we are calling for is for governments in the global south, as well as the boards and the very wealthy shareholder of at least Serum, Johnson & Johnson, and Pfizer, and the Geneva-based not-for-profit initiative, Gavi, to take the necessary steps to ensure that this type of bullying, because it really was bullying, and extremes of non-disclosure are not repeated in the next pandemic or the next epidemic. We really need open procurement processes, not secretive ransom negotiations. Thank you.
Thank you very much, Fatima. Our next speaker is Jay Cruz from the Public Service Accountability Monitor in Makanda in South Africa. Jay, over to you.
Thank you, Marlies, and good day, good afternoon, good morning to those on the call. So I was tasked alongside fellow colleagues in the multi-stakeholder task team to consider the Johnson & Johnson contracts, or those signed with Janssen, a Belgium-based pharmaceutical company, and there are three documents that have been released at this stage, but the most significant of those were the initial advance purchase agreement that was signed, and then there was an additional agreement to secure additional doses. And as Fatima has explained, these contracts, when one considers them, one can see very clearly a strong bias towards the pharmaceutical companies. The conditions favor them significantly, and I'll touch on just a few aspects. So the delivery terms in the contracts were very vague, allowed significant scope for the pharmaceutical company, in this case Janssen, to deliver not on a fixed time frame, subject to a range of conditions, which really did put the government purchaser in a difficult position with very little leverage over the arrival time of doses. As Fatima noted earlier, there was also restrictions, or the Janssen was permitted to export doses if it so pleased, even if they were manufactured, of course, here and were then preferred to countries outside of Africa. Another clause that is of what remains of serious concern is the confidentiality clause, 2.5 pages of a 46-page agreement containing extensive confidentiality conditions. In addition to that, the indemnity clause, section 17, provides extensive cover to the pharmaceutical company, and really does put the government purchaser in a very difficult position. Had these contracts been released more earlier to the public, it would have supported engagement around pricing. As one will see, South Africa paid $10 per dose, more than many other countries, especially those in the Western and from the global North. And that requires further investigation. There's also reference to a not-for-profit framework that Janssen undertook to develop. It's not apparent that not-for-profit framework has been used or allowed for an adjustment to the price downwards, so that the government purchaser, in this case the National Department of Health, would not have to pay as much as they've had to pay. So yeah, there's certainly rich material here that will be the subject of further investigation, but I'll pause for the time being and return to Marlies.
Thanks very much, Jay. Next in line is Professor Matthew Herder, who is going to talk to us about the Pfizer contract. Over to you, Matt.
Thanks, Marlies. I want to start just by congratulating HJI on this victory. I think it really is a victory for transparency that has global implications that I hope will change practice moving forward. So congratulations again. So speaking specifically about what the Pfizer contract reveals, I wanted to make a few points. The first one is that it is, in a broad sense, similar to some of the contracts that have been leaked in other countries. It has sweeping indemnification and confidentiality clauses, and at the same time, there are really few, if any, measures to protect the public interest built into the contract itself. That's similar to what we've seen elsewhere. But in another sense, it's much more extreme. The language of its provisions, they are far more in the company's favor and Pfizer's favor compared to some of the other deals I'm familiar with. So for instance, the South African government is prohibited from sharing the doses it needs, for instance, to a neighboring country, if that neighboring country might be in need. They cannot do so without Pfizer's prior written consent. And unlike other procurement contracts, Pfizer can withhold its consent for however long it sees fit and for whatever reason it chooses. Similarly, Pfizer has sole and complete discretion over where the vaccines are to be made and supplied for South Africa under the terms of the contract. No commitment whatsoever is made to local manufacturing, even though Pfizer had a pre-existing partnership with a company in South Africa, BioVac. The contract also does not guarantee that Pfizer will actually deliver any vaccines to South Africa. And in the event that they don't actually deliver, the most the South African government can recoup is 50% of the advance payment they were required to make under the contract. That kind of term, limiting the amount of repayment, is not at all standard, in my view, for advance purchase agreements. Finally, in addition to sweeping indemnification provisions, which required the South African government to hold Pfizer, quote, harmless of any and all claims against it, as well as to bear the costs of any product recalls if that needed to happen down the road. The government would be responsible for covering those costs as well. Pfizer actually required the South African government to set up a vaccine injury compensation program as a condition precedent for delivering any of the vaccines that were contracted for. So taken together, from my perspective, these provisions shift virtually all of the risk, all of the cost, all of the burden onto the South African government, which at the time this deal was struck back in early 2021, had virtually no vaccines for the country's people. So that certainly feeds into this very strong impression we have from reading the contracts as a group, that it was a very one-sided endeavor in the company's favor. I'll leave it there for now.
Thank you. The speakers are very short and sweet, even though my timer is saying they still have plenty of time. Thank you, Matt. Professor Brooke Baker, would you like to go next? And you're even allowed to steal some of Matthew's seconds if you want.
Well, maybe that will be useful because we'll be talking about Gavi's COVAX program, which, as people may remember, was set up to prioritize access to vaccines and ultimately to diagnostics and therapeutics for low and middle income countries. But seemingly in disregard of something we haven't discussed so far, which was the vaccine nationalism, diagnostic and therapeutic nationalism that led to hoarding in the global north, many times the number of doses required for populations, which the drug companies preferentially supplied. And so that's a background of this analysis, is that the global north got the doses it needed in very short order, often paying higher prices, but sometimes lower prices. And the rest of the world was left to wait. The COVAX program was set up to equalize access, and to be equal, it needed to be both timely and in sufficient quantity. And if we look at what happened with the Gavi's COVAX program, we would say that particularly in South Africa, it failed in virtually every respect. Whereas there was urgency, and South Africa was one of the first countries to recognize the urgency and even promoted the TRIPS waiver proposal at the WTO to try to expand the number of manufacturers and overcome the monopoly barriers that those companies had on their products. That urgency was met with protracted delay. Gavi had promised, or at least projected, I guess we should say projected, because Gavi never really made fully committed promises, but it projected to supply 20 million doses by the end of 2021. And it fell far, far short of that. And in many respects, the Gavi contract, the COVAX contract, is illusory. And I say it's illusory because it guaranteed no number of doses. It had no guaranteed price, nor even a disclosed price. And at the end of the day, South Africa got somewhat over a million doses from COVAX. That was all that it was actually able to deliver, approximately a tenth of what it had originally projected to be able to supply in very quick order to South Africa. So there was a lot of fanfare about what Gavi and COVAX were going to be able to do. Gavi and COVAX raised over $10 billion towards the procurement of medicines, but then countries like South Africa were left without access. And really one of the reasons they turned to the other contractors, to the monopolists themselves, is because COVAX did not deliver. But on analysis of the contract, we see that it didn't really promise to deliver. Like with the other contracts, there's also massive indemnification and guarantees running to Gavi from South Africa that it will absolve Gavi of any and all losses whatsoever. It will pay for its expenses, in the price. It will pay for some speed, though speed never happened, and indemnify for taxes as well. So I think one reason to emphasize the importance of COVAX and the failure it represented is similar approaches may be proposed in the future with respect to pandemics. We have so-called multi-stakeholder efforts that sit on top of existing monopoly power. And if those multi-stakeholder efforts, like Gavi's COVAX, like the Access to COVID Tools 19 Accelerator overall, or like the currently proposed medical countermeasures platform, if they are going to basically protect existing monopoly power, we're going to see the same kind of abusive contracts when countries have to turn to companies in the future. And I'd like to reemphasize what Fatima said. Although we can blame the monopoly corporate power for imposing these conditions, we also have to question the decisions by governments to go along with that. Trade secrets are not something that fell from the sky. They didn't come from God. They're rights granted by governments on self-defined issues of what is confidential information, and why there is a price on peanut butter on every jar of peanut butter in the United States, but South Africans couldn't find out what the price of their vaccines were in the middle of a global pandemic, is an example of how trade secrets have run amok. Thank you.
Thank you very much, Brooke. I'm going to hand over to Nick Drieden from the UK, Global Justice Now. Nick, take us away.
Thanks very much, Marlies. And again, I will start by saying to Health Justice Initiative, well done. This has really provided a huge example for all of us around the world. We all need access to the COVID-19 vaccines. In the UK, we've had some access, but only to heavily redacted documents. Half of them are kind of blacked out, removing all the key information that we as the public need. So what you've done here is phenomenally important. And it's important because I think what the released papers show is that when secrecy is allowed to rule, big pharma, the pharmaceutical corporations involved gain tremendous amounts of power, and they use that power to undermine global equity and to undermine the public interest. And the public interest should be the thing, and global equity should be the thing that is absolutely at the heart of how we produce and distribute vaccines in the middle of a pandemic, particularly because, as we've seen from some of the figures here, this is a sizable proportion of the money that the South African government spends on healthcare every year. That money, therefore, should be democratically accountable to the people of South Africa. And so what I'm going to do as a result of this is to redouble our efforts to demand that the contracts the British government signed with the pharmaceutical corporations is similarly put into the public domain in the way that you've put these into the public domain. There's a couple of things that we suspected, but that have been underlined by these contracts that I think show how important this is. For me, one of the most important things that happened in the pandemic was how countries like South Africa were charged more for their vaccines than the richest countries on the planet. How can it possibly have been that South Africa was charged 2.5 times what my country, the UK, and many European governments were paying for what was effectively the same AstraZeneca Serum Institute dose? That cannot be right. It shouldn't have been allowed to happen. And I believe if this had been done in a transparent and democratic way, it wouldn't have happened. How can it be that my government, the UK government, was able to take 5 to 10 million doses from the Serum Institute at a time when we were one of the best supplied countries in the world in terms of vaccines, and the Serum Institute was pretty much the only factory that was producing vaccines, Western vaccines for the developing world, for lower and middle income countries. How can that possibly be? It cannot be right. And again, if this had been disclosed and had been organized and agreed in a democratic and transparent way, I don't believe it would have happened. So there are so many lessons that we need to learn here. As other speakers have said, sadly, this is not going to be the last epidemic of our lifetime, I suspect. And therefore, it's absolutely vital that we all scour through these papers, learn what happened, and understand ourselves how to organize things in a more equitable, just way that meets the public interest next time around. So thank you again. I'm really honored to be a part of this.
Thank you very much, Nick. Welcome, Tahir. Tahir, will you please provide a perspective from the US?
Yeah, no, thank you for having me join. And I would just want to really commend all the great work that the Health Justice Initiative and everyone on this team, on this call, has done to kind of look at all these contracts in such a short space of time. Just a few quick comments. And I just want to start with a quote from a former US Supreme Court Justice Louis Brandeis, who said, and you've probably heard this quote before, "Sunshine is said to be the best of disinfectants." And this is a great example of that, because the spirit of transparency and accountability needs to exist, particularly in a pandemic. But I think just generally, I think having worked in the United States for the last 8-9 years and worked in this field for the last 15-20 years, also having come from the private sector, these kinds of agreements, whether it be court documents, they often get redacted. And I have always asked the question, how can governments or anybody set public policy when we don't even know what a lot of these commercial transactions are? And so really, we're all operating very much in the dark. And so this particular exercise, this particular court case is hugely significant in terms of addressing the problem. The sad part is that, as with any major fight for injustice, it always happens after the event, and that we have to find out what really happened afterwards. And I think it's really imperative upon governments, particularly in the global south, but I think everywhere, to really start being accountable for the public first, rather than trying to protect the interests of the pharmaceutical companies or any other commercial actor that gains from these kinds of non-transparent agreements. One of the things that really struck me about the contracts, and we've heard this before, as Matthew mentioned in some other contracts that were leaked, is Pfizer seeking indemnification against any infringement of intellectual property. And I wrote about this in a paper a few months ago, where I think it's really, although I've realized now the pharmaceutical company doesn't do irony, is basically that on the one hand, they're trying to prevent a TRIPS waiver happening at the World Trade Organization. And then on the other hand, they're essentially basically saying we want a waiver from any kind of intellectual property infringement. And now if any of you have been following what's going on in the United States, there's a spate of litigation going on between the various COVID vaccines, particularly in relation to the lipid nanoparticle technology, which is what delivers much of the mRNA vaccine. And Pfizer's in a dispute now with Moderna. There's various other actors who had technology. So essentially, it was very clear when that first leak came out, I think it was in Latin America, one of the countries, and now we're seeing it here in these contracts. It was very clear that they weren't sure whether they had the full ownership of the intellectual property. And even so, even in the agreement that they've signed with the South African government, they on the one hand say, we're the sole IP right holders, but then we want indemnification from any infringement. And I think that is an astonishing contradiction and hypocrisy, that on the other hand, you're preventing the rest of the world trying to move forward and make vaccines where there's the capacity and capability, and yet you're basically signing these agreements to sort of indemnify yourself. I think it just goes to show all around how terribly how we cannot trust the pharmaceutical industry, how we cannot trust governments to actually do the right take the right policy choices. I mean, whether it be what they do, what country governments are doing in terms of implementing policy in relation to intellectual property laws, or whether it be how they sign agreements. Everything is towards the power of the pharmaceutical companies. And I think, particularly in the global south, and I'll say this as somebody who's from the global north, who has worked in the global south, I think the global south countries have to really look at their neoliberal policies that they're implementing on behalf of the pharmaceutical companies. They can sit here and start crying foul and saying, "Oh well, you know, it's pressure from the United States or so on and so forth." But they're actually implementing these policies because they actually believe in it as well, in terms of some of these things. And I think that's where the pressure really needs to be applied, if I'm going to be really frank, because that is what's really got a lot of global South countries into this mess as well. You know, whether it be from 1995 from the WTO and continuing the sort of the trajectory. If you look at India today, India is very much sort of being weakened as the pharmacy for the poor because of these kinds of policies. And I think it's important to look at it on a bigger picture rather than also just these contracts.
Yeah, thank you very much. And I want to send a shout out to all our panelists because my laptop is saying exactly 2:30 and we had 7 speakers and everyone was spot on. I want to thank our panelists and I want to direct the attendees to the URLs that we have pasted in the chat box where you will find the documents and the analysis that our multi-stakeholder group has prepared. I'm going to open the floor for some questions, and my suggestion is going to be that we take 3 live questions, so if people want to put up their hands, and then 3 questions from the Q&A. If you feel like rather typing up your question in a Q&A than speaking, you are more than welcome. I'm seeing a number of hands coming up like a wave. Let me start off with Rosa. Rosa, would you like to introduce yourself and where you're from and give us a short question? We're going to take 3 and then I'm going to hand over to the panel. Rosa. Althea, could I ask you just to check that the participants can unmute themselves?
Hi there, I think you should go now.
I can hear you. Thanks, Rosa.
Hi,
go ahead.
Sorry about that. Hi, everyone. Thank you so much for today. I'm a global health reporter at the Bureau of Investigative Journalism. We were the team that was able to report first on the Pfizer contracts coming out of Latin America, and followed up then with a piece in South Africa where we believed that the South African government had been able to take out a specific clause related to sovereign assets from their Pfizer contracts. I wondered, could you confirm whether or not sovereign assets were covered in the Pfizer contract, please?
Thank you very much, Rosa. I'm going to take 3 more. Let me just see who was next. If someone can help me. Let's see. Ashley Furlong, I see you are next on our list. Please go ahead, Ashley.
Hi, thanks so much for taking my question. I'm a health reporter at Politico. It seems like the release of these contracts has shown how little say governments in the global south had, obviously particularly the South African government. We've seen from the contracts released, the redacted ones in the EU, for example, that they were similar. They didn't also have that much say either. But I'm wondering in the future what you think the Western governments could do to push back on these things like indemnification, confidentiality, etc. As obviously we'll know in the future that governments in the global south will likely still not be able to push, if they are still at the back of the queue, for example. So I'm wondering what you think governments from wealthy countries could do in the future to stop these precedents being set on things like confidentiality and indemnification. Thanks so much.
Thank you, Ashley. Christian, you are next. Hi, Christian, if you can unmute yourself.
Yes. Hi, it's Christian Du Plessis here from Netwerk 24 in South Africa. My question would be just for the sake of balance here. You referred to South Africa having very unfavorable terms in relation to other countries especially in the global north, especially when it comes to pricing. those countries did upfront give investments for the development of these vaccines when they didn't know it would work or not, well, while the South African government did not do that. Can that not be a justification for this? I would just like to hear the thoughts of the panel. Thank you.
Thanks very much, Christian. I see we don't have many Q&A written questions, so I'm going to go on with all the hands. Tamar, do you want to go next? And then I'm going to take Kerry, and then I'm going to open it up to our panel. Tamar? Thanks, Tamar. You can unmute yourself.
Hi, this is Tamar Khan from Business Day newspaper. The South African Health Department repeatedly ducked questions about these vaccine contracts, saying it had signed non-disclosure agreements. And yet there were times when it did disclose aspects, including some comments to Parliament. I'm just curious, in the work you've done looking at these contracts, are there any specific clauses in them that impose penalties on the government if it does go public? I'm just curious to know whether they're in there and what your thoughts are about what the consequences for the government might be now, having complied with the court order, but potentially breached those NDAs that it agreed to with the pharmaceutical companies and COVAX. Thanks.
Thank you very much. Kerry, I'm going to give you the last word. Please go. Thanks, Kerry.
Thanks. Hi, thanks for the question, Kerry Cullinan from Health Policy Watch, Geneva. There's a global negotiation for a pandemic accord to try to prevent this kind of thing in the future and to try to foreground equity. But as Tahir says, we can clearly not trust the pharmaceutical companies or governments because politicians want to be re-elected, and we just saw the rise of nationalism. So who do you think should be in control of allocations of vaccines in future pandemics, and how can that be enforced at an international level? The WHO has said that it should be allocated 20% of any products that are produced in future pandemics, but that's obviously not enough. Thanks.
Thank you very much for the incisive questions. I'm going to suggest that Fatima tackles some of them, and Jay, and then we'll see which of the questions haven't been tackled, and then I'll ask some of the other panel members to please give us their thoughts. Fatima.
Thanks, Marlies. So just to remind you all, the link to the contracts and our analysis is now live on our website. If you have difficulties, let us know. Marlies has put it in the chat, and that, Jeffrey, actually has all the different prices and the differentials. I haven't slept for 4 days, so I can't give you the exact numbers, but the correct numbers are in the analysis document. If you open it, you'll see that in almost all cases, we're just not sure why we paid more. And I'll come to Christian's question just now. So let me deal with the assets and Pfizer question, and let me deal with the penalties and the legal court order and what that means for the companies. And then I'm going to ask the panel if we can ask Brooke to deal with the accord and the current negotiations around the IHR as well as the UNGA coming up. And then if we can ask Nick, Tahir, and Matt to deal with Ashley's questions, as well as some of the broader issues around the NDAs and confidentiality. So from a South African perspective, and Nick and Tahir and Brooke can come in on the global perspective, and Matthew can in fact tell you about the challenges they've had in Canada about trying to get access to these contracts. So the issue of secrecy, I think all of you are right, is a global concern and a crisis, and we do need a global solution to dealing with the real very worrying levels of power. We've called it pernicious power. We've been calling it that for the last 20 years. And our concern is that it's getting worse. MSF has just in the last 2 weeks indicated that pharmaceutical companies after COVID are now insisting on even broader NDAs and confidentiality agreements, so much so that MSF has decided not to sign a really important agreement that wanted an NDA with a humanitarian organization on a very important drug. So in relation to Pfizer, they backed down on the sovereign asset demand in respect of South Africa. Thankfully, we were able to rely on a lot of your work, Rosa, at the BIJ and others, that were actually trying to tell us the story and give us the early warnings in the pandemic. And I think that also shows why journalism and investigative journalism is so important. But unfortunately, in many countries in Latin America, and some of our colleagues from Latin America couldn't be here, they did demand state buildings. They did demand total control over the government's bank accounts. But in South Africa, the one good thing the then minister did, as you know, he was controversially removed. He was alleged to be involved in corruption. But the one good thing he did was to actually make it public that Pfizer was demanding national assets of South Africa for surety. In the end, what Pfizer did was they backed down on that requirement. So we didn't follow the Latin America route. But what they did do was actually make our government set up, as Matthew explained, a very speedy, probably the most expedited parliamentary process we have ever seen, even faster than us for the last 4 days working on these contracts to set up a vaccine injury compensation fund. And you'll remember that that had a significant impact on the pace at which deliveries could come into South Africa, because both J&J and Pfizer said, if you don't set up this new, quick, fast, legally expedited vaccine injury fund with all of the underwriting being done by the South African government, they will not give us a single supply. And what we found, and Brooke can confirm this, was that COVAX also asked for indemnification, very broad indemnifications as well as serum. And there's an irony with the serum contract. I think, Joyty, you asked a question in the Q&A box, because it's definitely not a contract that, it's one global south country favoring another global south. These are pharmaceutical companies and they all have the same interests in mind, and that is to have total indemnification, extract, the highest price possible and have a lot of secrecy. So I hope that answers the questions around Pfizer. I just want to clarify in relation to Tamar's question that there is no breach of any contract. We have included the confidentiality provisions in our analysis. And this is the reason why we say we are so surprised that our government spent all this money and time resisting what was a very simple access to information request almost 2 years ago. There are confidentiality provisions, yes. We've asked if there are separate NDAs, and our lawyers are waiting for an answer on that. But the confidentiality provisions, even in the court hearing, when Miller J asked for a copy of one of these confidentiality agreements, clearly makes provision that if a court of law orders disclosure, that there would not be a breach. We included the confidentiality provisions and disclosure provisions in the analysis as we received them from the department. Clearly, somebody was highlighting it in the National Department of Health, so you can see their highlights. And what it does include is a duty to inform the relevant parties if a court does order disclosure. We assume that that has happened. We must trust that the department has done their job. That's not for us to deal with. But basically, it also means that this didn't have to go to court. This was totally an unnecessary legal action. If somebody had read these contracts properly in the confidentiality clauses, and the irony, I think, Tamar, just the final point on that, is that the COVAX agreement doesn't even have a confidentiality clause. So the basis on which somebody was protecting Gavi or COVAX and not disclosing that agreement and invoking this, this idea of an NDA, for example, over all the different parties is just beyond us. Now, does that suggest that there's something that there's a level of inadequacy in the Department of Health and the State Attorney? My personal view is yes. I don't think they truly understand. I don't think we have the right negotiators, and I don't think we have the right contract experts. And maybe that has to be one of the remedies going forward. Let me turn over to my other panelists to answer the other questions. Thanks.
Thank you, Fatima. Brooke, do you want to tackle the question about the pandemic accord?
Yeah, before I do that, let me just supplement what Fatima just said about why, the enforceability or penalties for non-disclosure. I think that the real threats are indirect. basically the companies require a non-disclosure agreement before they enter into negotiations, and they say they won't negotiate for a purchase and sale agreement unless there is a non-disclosure agreement. They did that with the countries. They did that with Global Fund. They've done that with UNICEF. They've tried to do that with Médecins Sans Frontières. So the companies basically say, we won't talk to you unless you promise not to disclose that we are even in discussions with you. Then they have a separate confidentiality non-disclosure agreement in the agreement itself. And the implied threat is, if you breach this, we won't deal with you in the future, or we'll be impose even more onerous terms and conditions in the future. So I think, although there's, South Africa doesn't have to pay $1 million to Pfizer as a result of this decision, the power the companies have because of the protection of these implied threats is quite real. Now, on the pandemic accord and who controls allocations, well, that's in essence, it's a problem with the whole setup. We give private right control through intellectual property monopolies to companies that maximize their commercial interests and profiteer to the maximum. It gives them the right to artificially control supplies because they don't share the technology with other producers. We let them unilaterally set prices, and different prices for different countries, sometimes more advantageous to some and less advantageous to others. And we let them decide who they distribute to and when. When you vest all of that power over essential public goods in the hands of private companies, with governments or no other multi-stakeholder or international institution that can override those commercial decisions, you get exactly what we got in this pandemic. And unless the pandemic accord is willing to address intellectual property monopolies and power over supply, price, and distribution, we will have exactly the same thing in the future. So Carrie, I know that you're following the pandemic accord process quite closely, and the issue of allocation is critically important. But fundamentally, the power of allocation is still being left to the companies. And even when they talk about voluntary agreements on mutually agreeable terms, like AstraZeneca had with Serum Institute, for example, Serum Institute still acts in the same way to some extent with respect to supply, price, and allocations. So we really have to reconsider the procurement and allocation to be other than under purely personal, private control by the companies. I'd like to just briefly answer the question that Ashley raised about what could countries do, rich countries do. Well, they can impose transparency requirements in their research and development funding agreements. They can say you must disclose your future purchase and sale agreements with respect to the research that we develop. You have to disclose many other things. It's not just transparency about agreements, but there are many other things where we need transparency. We could have different legal rules that countries could adopt to require disclosure of such contracts as a matter of public law, or to create public interest and public health exceptions to trade secret laws. There's lots of things that governments could do, rich governments and poor countries, to overcome this self-declared secrecy that drug companies use to maximize their profits.
So, Marlies, can I just add to the penalty diversion point that Brooke mentioned before we
go ahead?
And I think that was Tamar's question around penalties. I think, Tamar, the most, why we call it one-sided and the most egregious thing, and Jay and I were talking about it yesterday, is that both the J. Cruz, not J&J, but both the J&J, Johnson & Johnson, and the Pfizer contracts in particular, and I'm just talking about those two because that's where we basically were begging for supplies from and eventually got most of our supplies for our vaccine program. They don't impose penalties on themselves if they are late with deliveries or don't deliver. So the drip feed we saw in South Africa in 2021, where we were all waiting for vaccine after wave of infection, hundreds of thousands of people getting sick and dying in our country, and the frontline of healthcare workers being devastated. There is no penalty on any of these companies. And that was the ransom negotiation, take it or leave it. Not just indemnification fund, not just the inflated price. It's no penalties for late deliveries, no penalties for no deliveries. We can't divert supplies. We can't sell, we can't donate without permission from them. In one contract, they talk about reasonable consent. In one, they don't even talk about whether they can withhold it unreasonably. But they can divert supplies, and that is the scandal of J&J. So when you talk about what needs to happen, well, first we need to accept and understand that CEOs cannot be making these decisions. They are unelected, they are not officials. It's not even the WHO deciding the allocation decisions. It's the CEOs and the senior management teams of these companies. So they imposed language in these contracts that we as countries, as governments, can't divert supplies, even for humanitarian or charitable purposes. But they can divert supplies, which explains why at least 30 million vaccine doses left the Eastern Cape in South Africa in the middle of one of the most devastating pandemics and waves of infection South Africa experienced, and it explains why J&J then eventually drip-fed us with supplies, because European customers were regarded as more important by J&J. And I think that has to be one of the greatest scandals of the COVID crisis in South Africa. Thanks.
Thank you, Fatima. Jay, Matt, so either of you want to tackle Christian's question about, given the investments that the global north have made in the vaccines, shouldn't they be offered discounted prices to those vaccines? Okay, Nick? No. Nick?
Tahir.
Oh, well, I mean, I think some of this goes back to Brooke's point, right? Which is, yes, northern governments did make investments in vaccines. In fact, we wouldn't have had any vaccines without those investments, because that's where investments in medicines tends to come from. But the crime that was then committed was handing that over to the pharmaceutical corporations to profit off. And I think one of the things that comes really clearly from these contracts is just how concerned the pharmaceutical companies are with their intellectual property on vaccines that they themselves had not invented. So that's for me what's crazy. Why on earth did the northern governments that paid for these vaccines suddenly privatize them? And I think there's something interesting that another member of the panel might want to pick up on. But if I saw correctly, and I think it was the Pfizer contract, Pfizer was actually interested in the South African government indemnifying them for any breaches of intellectual property it made itself, which is extraordinary. Pfizer granted itself the same intellectual property waiver that they were opposing for most countries in the world at the WTO. So it's and no wonder, because Moderna is now suing Pfizer in the United States for patent infringement. I think that's one of the real lessons, and I would encourage governments like South Africa, of course, to put their own public money into research and development for new medicines, and some of that is starting to happen, and that's great. But for goodness sake, learn the lessons from this pandemic from the global north. Don't then go and privatize and enclose that knowledge, because this is knowledge that should be used for the good of humanity and scientific progress.
Thanks, Nick. Tia, do you want to add one or two thoughts?
No, I concur with everything that Nick and everyone has said. I think it's kind of when you read the actual dispute that's going on between Moderna and Pfizer's actually telling Moderna's saying that they basically invented the whole mRNA technology, and then when you look at the court, the petitions in the patent trial and appeal board at the moment, and then Pfizer saying actually no, this was all invented in the early 90s and it was all public funded and what have you. It really does just go to show that they'll say one thing one day and they'll say another thing another day. And actually that happens all the time in the patent world. They'll argue that something's new and non-obvious one day in terms of science, and the next day they'll go out and say something's actually it shouldn't be an inventive if it suits their needs. And I think this is the problem in terms of actually understanding, to put to Nick's point, of how do we really set up a system which is really, when we talk about knowledge systems, which are so governed by intellectual property, and we have these, what I call sort of legal fiction lines drawn as to saying what's actually belongs to someone, what doesn't belong to someone in terms of proprietary knowledge. And I think those are some of the deeper issues which we're not going to obviously resolve on this call, but I think those are some of the conversations that we need to be having, particularly when it comes to pandemic preparedness and related issues. Because at the end of the day, to the question of, well, if the US government invested, then do we have a US government policy problem in terms of they're pushing these kinds of sorts of policies onto the rest of the world? Companies are going to do what they want, what they're going to do anyway to serve their shareholder interests and their private interests. So in a way, I think we in the global north have a huge responsibility to change policy in our countries in the global north, because at the end of the day, when we look at the history of whether you could talk about the WTO, what's happened over the last 50 years, it's been the global north that has actually followed these kinds of interests of the pharmaceutical, the commercial world to push these kinds of agreements, whether it be investor-state dispute resolutions or these kinds of commercial contracts, which they're allowed to get away with. So we all have a lot of work to do in our respective territories, whether it be the global south to not keep taking these kinds of policies in, and the global north to we need to push back and say, actually, this is not serving the larger global interests.
Thanks very much, Sigurd. I think it's also worth mentioning the contribution that global south countries have made in terms of clinical trial participation. We know that thousands of people from the global south contributed to the science and the testing of vaccines, and that role has not been acknowledged. There are two more questions in the Q&A, and I'm going to ask Jay. The first one is from PSI Asia, who asked, how do you analyze the role of the Serum Institute of India? Looks like while Pfizer and J&J wronged the developing countries, a company from the global south didn't stand up for themselves either. And then the last question that I'm going to suggest we end off with is for Fatima from Zukiswa from Daily Maverick, who asks, what is next in terms of legal action after the end of September deadline for all the documents to be submitted? Jay.
Thanks, Marlies. I haven't interrogated the Serum Institute of India's contracts, so apologies. So I was preoccupied with the two contracts, the J&J contract. So apologies. I won't be able to offer the depth of insights under the circumstances. But yeah, certainly, if another colleague can speak to that, I think they'll do better than I can.
Thank you, Jay. You must have had a heart attack. Is there anyone else who wants to take the Serum Institute question?
Nick, Serum and AstraZeneca.
Yeah, I mean, I think we still don't know, because we don't know at the moment the cost of production from the Serum Institute. So we just don't know how much it was costing them to make this stuff. What we do know is that they ended up charging, as I said, 2.5 times what AstraZeneca was charging the UK, and AstraZeneca was charging the UK what it described as cost of production. So there are serious questions to be answered there. Did it cost the Serum Institute, in fact, more to produce it? If so, why? And why were more factories not also given the knowledge so that they could produce at a cheaper price? You know, there's an interesting thing about the Serum Institute, which is the Oxford inventors of the vaccine actually shared the vaccine know-how with the Serum Institute unofficially and secretly before the AstraZeneca contract came into effect, because they were so worried that AstraZeneca wouldn't actually do a deal with the Serum Institute. So they had that medical knowledge for quite a long time before they began pumping them out. Why was it so expensive? We still don't know. But look, I think it's definitely fair to say some of the generic companies we're talking about here are not angels themselves. And the idea is not you have one baddie and one goodie in this situation. It's that the whole way these medicines were distributed and produced was wrong. Something's wrong at the heart of the system. And that's what we're here, I think, to try to change.
Thank you, Nick. Fatima, you have 2 minutes.
Yeah, so just on the UK AstraZeneca saga and Serum, and why we had to sign a contract with Serum, and so leaving aside the decision by cabinet to not use the vaccines, and we've dealt with this in our analysis, is that both J&J and AstraZeneca in their licensing deals with Aspen and then Serum Institute had control over 2 aspects. So it's not even control in relation to governments, but it's also in control in relation to the licensees. And in those contracts, what we believe is that the UK was regarded as a priority customer. So think as your first class in an aeroplane flight. And so the Europeans, and this is why we call this imperial-minded and colonial, and people from the UK, because of that investment in the initial part of the initial research, it was actually public researchers, were basically considered priority customers. So both Serum and Aspen had no control over two things: the price that they would set, that's what they've said, and the allocation of supplies. The supplies went into a global pool, and then that's how the J&J vaccines left South Africa. And similarly, that's how the UK also over-ordered and received supplies, not just from AstraZeneca and other companies, but also received supplies from Serum. When they announced the deal, they said that Serum would actually supply the global south. When they announced the deal for Aspen and J&J, they said that the vaccines would go to Africa. But what we've learned is that Europe matters more, and so the vaccines went there. And then, Christian, just to your issue about, well, if there's if there's R&D, that's research and development, isn't that the incentive? Yeah, in some cases with Operation Warp Speed and the UK's government of those particular vaccines, they got some concessions, but it doesn't explain why AstraZeneca then still charged the EU less. I mean, you'll remember there was a whole issue about their supplies. There's a dispute. They went to court on that. So there is an uneven preferential pricing framework. Nobody ever understands in the pandemic what's the basis of that. Why is that? And until you actually have transparency in price setting and proper price regulation, and that requires proper antitrust or competition law, you're not going to get to the bottom of that. But if you look at our analysis, you'll see the exact prices. Joe has done some rough of the, back of the envelope rough numbers. And I mean, we do know it was reported in Parliament, at least about 11 billion Rand. We've calculated all the advance payments, the down payments, all the money we can't get back, because that was the other thing. They gave themselves a concession that even if they didn't deliver and you paid a down payment, you wouldn't get a refund, or you'd get a very low refund. So, I mean, we were really bullied. And it's not government's money that is lining the pockets of these companies. It's our money. It's money of people in South Africa, where our government can't even give a universal basic income grant, but we're paying additional money for supplies, and we're also paying money for supplies that we never got, or that came late, or didn't come at all. And Joe's number is around 14 billion in 2023 terms. But we'll send you as a follow-up, Angie will send you the follow-up of how we've come to those calculations, but it's also in the analysis. And then just finally, let me add by saying that, it's great that the minister didn't appeal, and it's wonderful that the president says beautiful things on global platforms about vaccine nationalism and vaccine apartheid, and he's talked about Africa being in a begging bowl. But the question really is to the South African government: what are you going to do now, and what are you going to do next? And so Zukisa's question about Daily Maverick, from the Daily Maverick, about what's next for HJI is, yeah, we're waiting for the rest of the documents. We really want to see the negotiations with Moderna in particular, because that does have an impact for our work on technology sharing in respect of the mRNA hub in South Africa. But I think what this whole saga has shown us, when we've spent the last 4 days, all of us just, in utter disbelief, that this is the level of power of these companies, and that our government, with a constitution in a robust democracy, is powerless, or has told itself that it's powerless to actually resist this kind of power. So it is tied, and this is all of Tahir's work at IMEC, it is tied to the way in which these companies believe that they can act above the law because of their patents and their patent-seeking behavior. And our next case is going to be taking on the Minister of Trade and Industry, Minister Patel, because we believe that the way in which these companies are acting derives from a monopoly that they get in the way in which they seek patents and are granted patents so easily in South Africa. There's no opposition mechanisms for civil society in our country, even though the international trade agreements allow that. We've been waiting for over 4 years for the minister to table that law. We thought he would do it in the middle of the pandemic, but our government went to Geneva to fight for a TRIPS waiver, but back home couldn't even table that law because they are scared of either the US government or these pharmaceutical companies. And now we know why they are so scared, because basically, if you, as the minister said at that time, we had a choice. We had to choose between the people in our country or we had to choose between fighting the pharmaceutical industry. So what's next for us is trying to address some of these systemic issues that make these companies believe that they can exercise this much power in a very unaccountable way, and frankly, in a very pernicious way. Thank you.
Thanks very much, Fatima. And I'm going to suggest that we end off here. Matt, thank you very much for the valuable comment in the chat box. I apologize to the others who still had questions that we can't get to this afternoon. You will note that Angie will be our press liaison if you want to get into contact with her about follow-ups or other requests. And I would like to conclude by thanking our panel and thank you for everyone who participated this afternoon. Thanks very much, everyone.
And thank you to all the organizations that helped us. Really appreciate it. If you guys want to stay on, just wait a few seconds. Shrey, you want to stay on? And Al?
I can stay on for a couple of minutes if we want to.
Just waiting for the rest of the journalists to leave. Sorry. Miss Chen, it's okay, you can leave us. Christian, Jeffrey, Hein, and Sarah, do you want to, you can leave us, it's fine. Althea, are you able to remove them maybe? Or not? Will they get into trouble?
I'm removing them one by one. Sorry, peeps.
Don't remove Joe and Angie. Where is Angie now? Oh shit, we lost Nick and...
They left already.
Nick
I
and
think they
Ty.
left on their
Okay.
own.
Yeah,
I didn't remove them, I promise.
Hi, Al. Please, can I suggest that we have any catch-up conversation on a separate link for security purposes?
Okay, all right. So then, thank you everyone, and then bye.
I can send a separate link.
And
Thanks
you
very
want
much.
to do it right now? Okay, so I'll look for a link.
I think, could you set us one up now? Thanks. Bye everyone.